Welcome, everyone. My name is Marcus Gehring. It's my great pleasure, also on behalf of the directors of the Lautput Center, to welcome you to the Friday lunchtime lectures here in the room and, of course, also online. It's my great pleasure to welcome Professor Richard Barnes, who's Professor of International Law at the University of Lincoln and Professor of Law at the Norwegian Center for the Law of the Sea at the University of Tromsø. His research focuses on the human right to property, ocean commons, and BBNJ. He's widely published in the field of international law and law C, and has won prizes for his work on property rights, natural resources, as well as plastics regulation, international environmental law on the oceans and climate change, and the United Nations Convention on the Law of the Sea as a living instrument. Professor Barnes is a member of the ILA Committee on the Protection of People at Sea and has acted for various organizations, including WWF, Planet Earth, Oceania, the European Parliament, and the UK Department of Environment, Food and Rural Affairs. He's provided advice to foreign ministries and it serves on the editorial board of many of the most prestigious journals in Europe in international law. So it's my great pleasure to welcome for this Friday lecture on property rights at sea, Professor Richard Barnes.
Start my timer and then ignore it. So, well, Marcus, thank you for the very kind introduction. So, listening to all that, it makes me think, one, I'm either spreading myself too thin, or two, which is more likely that I'm just getting old and everything's kind of accumulating. So, but thank you. It's a very kind introduction. It's a pleasure for me to be back in Cambridge to talk. It's been a while since I was last in Cambridge to give an academic talk. And it's also nice to be back because I was a master's student here way back in 1995, 96. And actually, it's quite a kind of turn to be sat here talking to an audience at the Loud to Pass Centre rather than listening to somebody. So I feel like I kind of come full circle. It may have taken me some time, but I'm delighted to be here. Okay, so my talk today is about the right to property, but more particularly, it's about the human right to property in ocean spaces. And this really, for me, is a bit of a new project, but it's also something of an old project where I revisit my PhD. And it's a kind of a bit of a stretch between the two of them. So my PhD was actually on kind of fisheries. I looked at the privatization of fisheries. And I was kind of struck at the time, there was a lot of literature, particularly from an economics perspective, which was advocating what you might call the privatization of the oceans or advocating the privatization of fisheries. And in large part, that was response to the kind of well-known problem of the tragedy of the commons. The idea there is no restriction on access, then there will be an incentive to overexploit a resource. And so privatization was a way of preventing that overexploitation of resources. And there is a kind of logic to that. It has a kind of nice environmental feel to it. The idea is that, this will deliver benefits by preventing overexploitation of stocks, which is a well-acknowledged problem. And that's fine as far as it goes. But I was a little bit troubled about maybe some of the kind of consequences of this. There's the question of whether or not actually those environmental outcomes are actually going to be achieved. But actually, when you start to privatize the oceans of fisheries, it generates quite significant knock-on effects in terms of distribution of resources. It has significant questions raised about equity. And so for me, if you follow an economic model, it largely or can ignore that. And the question is then whether some of these other considerations ought to feed into that. And so I was concerned and interested in the extent to which law, because in a sense, even if you're going to use law in an instrumental sense to kind of achieve privatization, law itself contains values, structures, and processes which actually might mitigate or prevent some of those economic outcomes from happening, and whether then actually law could be used to kind of offset some of the distributional consequences. So there's that body of research. But then more recently, I was asked to contribute towards the Oxford Handbook on Human Rights at Sea, which is being edited by Opalou and Anna Petrick. And I was asked to do the chapter on the human right to property. And I thought it was quite interesting to kind of revisit things. And for me, I think it was interesting because actually it kind of reveals some real fundamental tensions in the way in which potentially property, but the right to property as a human right, can start to influence or shape the way we regulate the oceans. And one of the kind of themes which I guess I will explore in a little bit more detail is the kind of tension at stake. Because what's clear from some of the jurisprudence on the human right to property, that it's very much concerned, using a Western tradition, with the protection of private property rights. And it's often framed in terms of limitations on what the state can do to interfere with private property rights. So it protects a sphere of individual autonomy from undue interference by the state. And there's value in that. But what that does at the same time is it consolidates and it concentrates authority within the hands of the individual. And so for me, what's not really explicit and what we need to think a little bit more is whether or not human rights discourse also has to have a kind of another function. And that's the one about shaping the kind of questions about equity, whether or not measures on human rights, whether or not the distribution of the resources, which are the object of those human rights, ought to be facilitated in a way which achieves other goals which are consistent with human rights, not just the right to property, but for example, non-discrimination, or for example, indigenous rights, which are all equally valid. So for me, this kind of question of the right to property at sea really kind of started to kind of become quite interesting because it gets to explore those fundamental issues. Anyway, so that's a long introduction before I get to the introduction. It's like a pre-introduction. So just a quick overview of what I wanted to talk about today. So I'm going to come back to about 4 sort of core questions at the moment. And I'll be honest, I don't have the answer to these 4 questions. These are kind of things which are kind of shaping my thinking at the moment about the role and function of human rights as relates to property there. But I think having kind of framed those, what I'd like to do next then is to kind of revisit what property is. And I think it's quite important, particularly, I kind of thought about this. I'm here at the Lauterbach Centre for International Law and I'm talking about property. What's property got to do with international law? Well, I want to try and draw out that kind of connection a little bit further and say why international law is more important to that, but also what property does and how we can understand it. Because I'll make the point now and I'll make the point again in a moment that actually there is a real gap and there is a lack of literature which kind of focuses on this kind of interface between human rights, property and international law. And I think if we're going to take this seriously, I think it's a kind of a research agenda where we need to do a little bit more work. So having said that, I'll then move on to talk a little bit more about the human right to property and to talk about where it's located, what it looks like, and what some of the kind of key jurisprudence says about this right. And then in the next section, try and apply some of that thinking to areas where property rights at sea exist. And depending on how much time I've got today, if I speak quickly, we'll get through a lot. And if not, I'll just do some select examples. But the kind of wider project I've got is trying to look at different situations where property rights arise, fisheries, shipping, marine resources, oil and gas, and just sort of see how those different kind of areas interact with this property. Then at the end, I kind of threw my conclusions together, but I'll provide some general reflections. But I'm probably more interested in the kind of questions from the audience. And for me, this is a work in progress. So yeah, please fire away and ask questions at the end there. So, okay, so the kind of core question I kind of started with here. So the first of these is that if we think about the oceans as a space between states, it's not within states, although some areas of it are subject to varying degrees of national authority. But given the oceans are fluid, they're dynamic, many of the resources move about, fish stocks, ocean currents, energy flows and things, they're never going to be exclusive to one state. So we have a kind of shared set of resources. We have resources which are between states. And that kind of poses some, I guess, kind of structural challenges, how we start to think about property. Because as I go on to say, property is traditionally a kind of private law institution, structured and regulated within states. But then if you take property outside of states, how do you kind of create a framework for starting to kind of deconstruct and reconstruct that notion? So part of what I'm trying to do is to provide that framework. Do I do it successfully? Yeah, let me know. The second thing is to think about property. Most forms of property have justifications philosophically, instrumentally. And so the question is, if we're thinking about human rights, which has, again, its own set of justifications, and property, then how do these kind of moral and kind of deeper notions then start to inform use resources within ocean space? So that's the second set of questions. The third one is to think about the kind of practical application of that. So it's all good and well having a structure, but we need to then give specific examples to show whether what I'm arguing works or doesn't work in accordance with that. And then the last point I'll ask you is more of an overarching question. So, and this is about how we balance individual rights and public interest in respect of property. And I think this is really, really important. And I think that gets back to the kind of initial tension that I suggested between how property rights protect individual interests, but the restrictions or controls or even the loss of property rights is often generated or justified because it's in the wider public interest. So how do we kind of balance those sets of tensions? And I think probably the main point I'll make there is that unless we have a really clear structure and sense of what these general interests or these public interests mean, then property, even through human rights, is always going to be vulnerable to capture by private interests, by self-interests. And we'll lack that ability to kind of properly balance the kind of interests at play. Okay, so I said I would say something about property. Just out of interest, I'm throwing in some images here on the slide. So this is like Pier and Ocean by Montreal. And if nothing else, and you don't like what I'm saying, at least you'll see some nice artwork. It's like, okay. Although, and I kind of, it's not a line point, but Sarabi and I were talking last night. And one of the things that we said, though, is that the challenge with regulating the oceans is that, one, it's a space beyond where most of us live and work and some travel. It's largely unknown, quite impenetrable. And because we don't have that close social connection, other societies have closer social connections, but I think by and large, most societies don't have deeper, profound connections with it. It becomes the kind of othered space, and that limits our kind of possibilities for regulating. So actually, in part, by presenting images and thinking about how we perceive and construct the oceans, then it can shape our thinking. So there's a kind of deeper rationale, but anyway, it's a nice picture anyway. So, okay, so property rights. The point I made at the beginning here is that the property is typically constructive as a kind of private right here. So when we think about the typical objects of ownership, we think about land, book, cars, pens, guns, all sorts of tangible and intangible objects. But most of these things are territorially grounded underground existing legal systems. And it's that domestic legal system which primarily shapes the way in property operates. The property itself is a kind of fundamental institution, and we think about property as a thing, but in legal terms, property is a set of legal relationships between people in respect of things. And because it's between people in respect of things, it has a kind of private law construct here. So that then begs the question, well, if it's really a kind of private law construct, then what does international law have to say about this? And why is a kind of an international law focus on how we construct property rights relevant, important here? And I think there are probably a number of ways in which we can look at this. So in some ways, we can think about property as being derived directly from international law. This tends to be more exceptional. But if we look at the Law of the Sea Convention, in particular the regime for the deep seabed, the common heritage of mankind, if we think about deep seabed mining rights, those regimes will create forms of property which can be directly accessed by individuals, primarily corporations. And so the source of those property rights is in fact international law. Now, it may be that then grounded in contractual regimes, which have kind of domestic law connections, but the kind of core parameters and the delimitation of those rights is primarily based upon international law. And if you look at the International Seabed Authority, it's developing codes for exploration and the kind of mining code for exploitation of those resources, which sets out in detail, or will in detail, the particularities of that. So there are a number of areas of international law where these things can be created. The rights are derived from international law. The second way is the kind of sovereignty property analog here. So ideally, Herschel Lauterplacht, private law sources and analogies here kind of looked at property as a kind of an analog of sovereignty, or sovereignty as an analog of property. And so we can think in particular of territorial sovereignty as a way of conceiving things in kind of ownership type relations. So in a sense, the state has territory, and that territory is a possession of or a part of the state. It's like having, possession in the human body or the human body. Now, it kind of works, but it works really only as an analog for kind of reasoning and comparing regimes here. Quite clearly, sovereignty is different from property. Sovereignty is a power of governance, whereas property is a kind of private law relationship. So there are limits to that, but I think it's kind of helpful. The third area is kind of more pragmatic here, and that's the simple fact that if the property is derived directly from domestic law, the authority to determine the scope of that will always be limited by international law. So you cannot, as a state, create property rights which are wider than or which infringe fundamental principles of international law. So kind of trail smell to polluter pays, you cannot create a property right which in effect gives a power to do something which the state itself is not able to do. So there will always be international law limits on property. And then the last one here is the kind of autonomous meaning of the property. And one of the things I think that some human rights scholars and researchers here is that when we look at, for example, the jurisprudence on the right to property in the regional system, pretty much all of them say that the right to property, whilst based in domestic law, has an autonomous meaning. And the rationale for that is if under human rights law, property is always derived and purely derived from domestic law, it becomes vulnerable to restrictions. So, for example, if a state said that you don't have proper title deeds to your property, negating your property rights, then if an international or human rights courts have accepted that, it wouldn't then be able to autonomously protect the interests of the owner of that property. So there is this kind of autonomous version of it. So in short, as part of the analytical structure, I think international law 1 is kind of relevant to this. So moving then on, though, so that's the first part of it, to sort of see where international law is relevant to this analytical structure. The second point then is to sort of talk about, well, what does property actually mean here? And I think one of the things that I think is important to acknowledge here is that whilst most states have forms of property, and the forms of property vary quite considerably between states, the structure and the content of those rights have what you might kind of call familial resemblances. There are kind of certain things about property which is common to most states here. So the kind of things which I draw out as kind of useful elements for the analysis here, first of all, to see property is not just a monolithic concept, but to see it as a bundle of incidents, the incidents of ownership. So this kind of goes back to Tony Honoré's kind of approach about property. So property comprises a series of dual relations, which include things like the right to possess, the right to manage, the right to dispose of something, the responsibility not to use it in harmful ways, the right to recover property if you've temporarily given it to others. So there are about 11 of these different kind of incidents. And that's quite important here, because then again, when we think about property rights, we think about ocean resources. We can think about how we can calibrate and manipulate and adjust that kind of bundle of incidents to achieve different types of outcomes. And for me, though, the one that's most important there is the kind of recognition that there are certain duties which attach to property. Whilst property is often seen as being excludability, the right of the owner to determine how things are used, nobody else can tell them what to do, certain restrictions. Thinking about the responsibilities which attach that is something which is a little bit underplayed, in fact, actually vastly underplayed in most structures. And I think probably my kind of view of this is that while property rights are there to protect individual interests, we have to remember that fundamentally property is a social institution. And the reason why it was created, was that there was a kind of collective public interest in constructing property. And we've got to remember that there is that sort of sense of duty to others, which is fundamental to the kind of structure of property per se, even not about excludability. So I've said something about excludability, and the last point I would say is because of the kind of forms of property, it doesn't have to take particular shapes. So in Western kind of doctrine, private property tends to dominate and is the object of discourse, and even within human rights discourse, that's the kind of favored mode of analysis. But we've also got public property or state-owned property. The state is almost like a de facto private owner, but it has ownership in order to control and manage resources, maybe for a wider public benefit. We've got common property, the right not to be excluded from a particular thing, which is typically paradigmatic of the oceans as a kind of commons there. And that kind of presents interesting opportunities because it shares sort of certain collective values, but also presents certain problems in the sense it can't maybe take away harmful users away from that kind of commons. And the last one, which I'm really interested in personally, is this notion of stewardship. The idea that you've got an alternative view of property, which is defined not so much about the benefits and gains for the individual, but the idea that you hold something primarily to benefit others. And I think that has kind of lots of potential for how we think about ocean resources and how, for example, human rights can start to inform that discourse. So that's the kind of the model of property. And then the kind of last element of my kind of structure here is thinking about the justification for property. I think one of the reasons why these are important here is because these kind of fundamental philosophical justifications for property are things that we need to bear in mind and think about when we're kind of analysing, critiquing how human rights might apply. And kind of jumping ahead a little bit, one of the arguments I'll make here is that when you look at the jurisprudence of the European Court of Human Rights in particular, less so with, for example, the inter-American and the African regional regimes, there is a really quite light and cursory reasoning of the kind of fundamental rationale for protecting or not protecting or for justifying infringements within kind of property rights. And that makes it quite limiting in a sense of jurisprudence. The European system is very, very procedural. You may disagree with this. So actually having this kind of set of kind of justifications is really important. This makes us think, why do we have property? Well, we have property because it will deliver certain outcome. So under the kind of labor desert theory, which we associate with John Locke here, the idea is that humans have property in their own body. And so if they then work on something, they transpose some of that labor, and then they become the owner of the thing that they work upon. So if you're a farmer and you till your fields, that justifies you getting the benefits of your labor there. And so for the fishermen, if they go out to sea and catch the fish, it's their industry which justifies the attribution of property rights. And there's a kind of nice rationale behind that, I think, although there are lots of questions then about socially productive labor. So if I go up and blow up Windsor Castle, do I own Windsor Castle's rubble because I've invested clearly no, it's got to be a socially productive use. And that's important when we think about fisheries. If I go out and commit fisheries through IU fishing, quite clearly I don't deserve any kind of interest in those. So we've got that. And then, anyway, and we'll see where we go with that. Liberty is an interesting one. So, people like Robert Nozick, mainly associated with this. And so the idea behind this is that if we give property to individuals, then it enables them to have political agency because it gives them the material things to be active, to be active actors, even the ability to engage in social norms. So, for example, if you're desperate for food, you don't have shelter, you don't have material, and if you don't have material, then that weakens your political independence, your personal agency. So if we give property, there is a precondition for that kind of form of agency. And again, we can look at how that might apply. Things like doctrine of permanent sovereignty over natural resources might be a manifestation of this. The idea that if states have the ability to use their resources as they see fit, It provides the material conditions for them to be active international actors or engaged or independent international actors. So that's another set of rationales for it. The third one is the kind of utility or economic argument. The idea being that, property in a sense benefits us all because it is productive. It creates, value added to a set of affairs. And so we all will benefit from that. And again, it's the kind of economic argument about the tragedy of commons, the idea that if we introduce ownership, it can prevent degradation, allows people to add value to things, and it's a socially productive activity. The challenges are, though, that kind of argument here ignores marginal interests, but it also tends towards the accumulation of wealth. So it has limitations. And the last of the justifications is one based upon propriety. And the idea behind this is an argument made by Carol Rose, among others, the idea that property is given to those because of their proper social standing, in the sense that because they are acting in a particular way, it justifies them having property rights. So in a sense, a farmer provides food for society, and so they have ownership interests in the means of food production because that is essential to their role. And so again, that can be kind of an argument which is extended how property facilitates good social order, but it obviously requires us to know what good social order avails. But again, we have kind of analogues here, though in part the justification for the exclusive economic zone was that actually states would be in the best position to regulate this space, and so it was proper for them to have title to or sovereign rights in the EZ. So we see those kind of right. So that's the kind of property and mode of analysis, and I think hopefully it can make sense. So then how do kind of the human rights property kind of come into play here? So I could read all of these different kind of statements about the human right to property. But the observation I'm making here is that within the Universal Declaration of Human Rights, in the middle there, within the European Convention regime, within the Inter-American regime, within the ASEAN regime, within the African regimes, all of these regional systems and the Universal Declaration of Human Rights recognize that there is a right to property. Now, how that is framed and how it is articulated does vary, and it may be worthwhile going into the kind of detail of the language at some point. But I think the observation that I'm going to make is that they all have the broad same structure. So it recognizes that there is a protected entitlement, and that's one space of autonomy, which is justified from interference by the state, but it's not an absolute right. Most of them recognize that there can be some form of limitation or withdrawal of that right, but only if some procedural conditions exist and only if is justified in the wider social interest. So I think pretty much all of them have that in terms of how it's phrased. There are kind of variations which talk about who can hold them. So there might be collective rights within the African regime, and there may be kind of like nuances in terms of what those kind of public benefits are in some regimes there. But I think the kind of broad structure of this is kind of there. So that in and of itself is fine, but it's kind of fairly basic. And I guess the next point I would make here is that despite this, there are kind of regional variations in how we approach these different types of rights. And I think, for me, this is quite interesting because if we think about the oceans as a common space, then how do these kind of different regional views permeate and influence what might be kind of common property? If we've got shared fish stocks, if we've got kind of marine protected areas, if we've got kind of resources which are kind of part of a commons like marine genetic resources, which of these kind of structures or sets of values are the ones which prevail? And what are the kind of modes for their kind of interaction? I mean, it may, in many respects, these don't happen because the kind of, things often happen on a regional basis. But I think there's still some important questions to ask about how these regimes interface. And I think it's not just a kind of an abstracted one. I think part of the rationale for this is a recognition that the regional human rights regimes actually cross-fertilize. And so the jurisprudence of, for example, we talk about the Andorra case later on here, actually explicitly uses jurisprudence from the European regime. So it becomes then a kind of space where different values interface and kind of develop. And then we get into kind of questions then, for example, how do more community-minded kind of concerns or regimes which are more favorable to the protection of indigenous peoples then start to inform and shape maybe jurisprudence and other fora. So sort of some interesting ones. So the point, though, again here is that property is secured, but constrained by unspecified general interests, unless we have a kind of clear sense of that, then sometimes it can be problematic. So the question is, how do we maintain that balance? And it just speaks now. So looking then at the kind of jurisprudence, so there is quite a limited amount of jurisprudence when we start looking at kind of ocean spaces. But there is kind of a much wider jurisprudence when we talk about kind of property more generally here. So, okay, that's fine. Just kind of running through some of these then briefly. So the kind of first point to note here is that the Human Rights Committee has addressed property rights concerns, but only indirectly. And the reason for this is because the ICCPR doesn't actually include a right to property. That's the kind of missing part of this. And part of that was at the time it was felt that it was too difficult to actually define and frame that as a kind of global norm. Although I guess at the end of the day, we've got there through kind of other means. So that doesn't mean that it doesn't recognize the value of property rights. So we've got, for example, the Apirana case in New Zealand there. And what we've tended to see with the Human Rights Committee is that it's protecting or facilitating the protection of human rights through other rights, for example, non-discrimination. And so in the Apirana case there, it was a question of whether or not customary rights to fish, which was secured through the Treaty of Waitangi to marry New Zealand, had been infringed by a decision to limit fishing rights for environmental and conservation means. And whilst the court of the Human Rights Committee recognised that that undue interference could infringe undue interference with the property rights could represent non-discrimination, the fact there'd been consultation and the fact that there were well-justified rationales for imposing conservation limits on this was a justifiable decision, and so the claim by Apirana in that case fails. We've got the case of Harald Sveinsson, which is Icelandic. Again, a non-discrimination case there. That case concerned allocations of quota under domestic Icelandic law. And the case was made there that the allocation to existing full-time fishermen and the failure to allocate to part-time fishermen was a non-discriminatory, was a breach of the obligation not to discriminate. Again, that was upheld there, and there was, and in part was because there hadn't been a proper rationale for what the basis of the distinction to allocate the rights between the communities was, though. So again, protection of property rights indirectly through the Human Rights Committee mechanism. Within the European Convention regime, there's really quite broad jurisprudence, and I think, given the kind of time limitations, I don't want to spend too much time about it, but there are kind of a number of kind of key decisions in this. So the decision of DePaul against France there is a kind of an interesting one because it concerned the building of a house in the kind of coastal zone. And the house is private property, was contingent a permission to allow the rights of access to part of the property, which was in the kind of common coastal zone. And for a number of years, the local authority, the prefecture, had said that's fine, you can access this. But then there was a change in the law to improve the protection of the environment, which resulted in the withdrawal of that right. And the question arose as to whether or not the right of the owner of the house had a protected interest under the European Convention, and whether or not there was a justifiable loss of that. And again, it's interesting there because the point was made that in this kind of common space, the state itself is entitled to regulate as it sees fit. And the owner of the property, the kind of entitlements which were enjoyed there, were always going to be vulnerable. And so when ultimately they were taken away, there hadn't been an undue interference with the property right there. And again, that sends out quite an important lesson for how we think about kind of the ocean spaces there and maybe the vulnerability of property rights. So I'll leave it at that, but I guess the kind of cases there sort of talk about the importance of following due process, the idea that any interference with property has to kind of follow a particular process here. So you establish the protected interest, you then look to see whether or not the restriction on that has been in accordance with law, whether it's proportionate and necessary, and whether or not it's justified by a kind of wider concept of public interest. And the kind of Marks case and the Sopron against Longroth cases are all kind of cases which concern that. Sorry for glossing over this. But what's interesting now is I think, generally speaking, the European Court has generally been quite deferential to how states make that kind of decision. They haven't really challenged said much about that. So going back to my idea here, that there is a real lack of consideration about what constitutes the kind of wider public interest. So there's a bit of a gap there. The inter-American regime, again, there's a couple of cases here, not necessarily oceans-based cases. And the reason why I kind of flag these is because they kind of conceive of property in a different way. One of the kind of key things here, a strong connection between spiritual, cultural interests and proprietary interests. So we've got the Yaqui case, now Tingi case. Both of these cases, I guess, kind of, I wouldn't say roll together, but what they do is they kind of strengthen the protection of proprietary interests by demonstrating the significance that they have for particular social, cultural, or spiritual values. So that idea of indigenous rights is a way of strengthening the kind of protection of property. And what's interesting there is that then itself has opened up a kind of wider space for considering, I think, what might be some of the kind of public interest. And the jurisprudence of these tribunals, I think, is interesting that. And again, in the Ndorwa case, Kenya, we've got of lots of land seized by the Kenyan government, but for tribal communities living in the Rift Valley. And in that particular case, again, it was recognized that there's been an undue interference with the kind of, even if it wasn't framed in terms of ownership, the proprietary interests of those. And again, it's the rolling together of discrimination, of indigenous rights, as a kind of package deal to show the kind of significance of the loss to these people. And the importance there, the kind of cross-fertilization of these values. So, some brief thoughts there on the kind of the way in which human rights has kind of framed the right to property. And again, sort of stressing there are kind of regional differences, but areas which I think are worth exploring. So how then does this kind of apply at sea? And as I said earlier on, there are kind of limited cases here. So I'm kind of riffing a little bit in terms of this. So if we think about kind of like a couple of areas, I'll do fishing and maybe marine genetic resources. So fishing rights. So in a sense, we have property at sea because, for example, most fishing is done under a license or it's done under a quota, and a quota is a form of property. Now, that property is not in the fish itself, but it's in the quota, which has value because it attaches to the ability to catch a particular amount of fish. So in a sense, we've not got property in situ in the sea, but we've got property which is used as a regulatory tool for harvesting resources there. I think the point to note there is there's a good rationale for that, and that's because it would just be simply impossible to have property in situ for fish in the wild. Unless we go out and label them in British passports, I'm not sure all would work there. So, but more seriously, the point I would make here is that kind of property, how it applies depends upon the material conditions of the thing that you're attaching it to. So for example, shellfish, which don't move, which are heavily localized, can be subject to fairly exclusive rights. But if we've got tuna or shared resources, it becomes problematic for the application of kind of typical forms of property which are individualized, because you can't exploit a shared stock without impacting upon the other co-owners or co-users of that resource. So they're a non-fungible good, they're a kind of common co-resource which is difficult to regulate. So the nature of the way in which we attach property to that reflects the kind of material condition of things. But we are starting to do that. And the challenge is, though, that if we do that in a kind of an unsophisticated way, what we start to then see is the kind of accumulation of wealth within particular holders. And if you look at kind of fisheries, the kind of story is now of consolidation, shrinkage, and the aggregation of kind of exclusive rights to fish in the hands of fewer small and of commercial enterprises. And that's been a kind of an ongoing drug test. And arguably part of the problem here is that has happened because no regard has had to the kind of wider distributional consequences of that. We've taken a very narrow view of why we create these, i.e. one based upon economic rationales, and we've excluded all those kind of wider proprietary and other considerations. I'm not sure whether we can impact that and change that kind of process, but potentially what human rights do is provide an opportunity for us to challenge and particularly engage with that. So we've got kind of recognition of a kind of different forms property. So in the South China Sea case, we've got vested rights. And again, another example where international law recognize or at least protect some form of private rights. So in that case, the kind of traditional artisanal rights of people fishing in the South China Sea were recognized and protected in archipelagic waters and the territorial sea, but they were just cut adrift in Z there because the creation of the EZ regime presumed the extinction of kind of those pre-existing rights there. But again, we can ask ourselves, if that had been done and we'd lost the rights, should there be some form of redress from that, and what would that redress be? We've got recognition within most regional human rights regimes that fisheries can constitute possessions and so are protected. So we've got the Alatukila case in Sweden, I think, which recognized fishing rights as a kind of protected interest. And that case there kind of recognized they can be protected, but again are subject to these kind of conservation and banishment rules. But stressing the point again, though, is that most of this case law at the moment is very much focused on protecting, and it doesn't really directly consider the kind of allocational issues. And so for me, the question is whether or not there is sufficient space for human rights to kind of move into that kind of space. I mean, the Good Johnson case and the Haraldson and Sveins Good Johnson case is a European Convention case which kind of recognized the jurisprudence of the But the European Court of Human Rights there stopped short of saying, for example, that we have to follow the jurisprudence and say that our allocational mechanisms and CFP, I think it was, should follow any kind of distributional consequences there. So they've stopped kind of short of that. We've got indigenous people rights. So, for example, the third committee there has recognized that the Kanak people in Canada ought to have had some protected fishing rights there, arguably on the basis of non-discrimination, but also recognizing their kind of cultural significance. Interestingly, in that case, Canada, also France, I think, still hasn't changed the allocation of rights to recognize that kind of judgment. So there's a bit of an enforcement or implementation gap there. And then more recently, we've got the Daniel Billy case in Australia, where the Torres Island Straits peoples brought a case against the Australian government for the loss of land and amenity and other kind of values due to climate change and sea level rise. And again, in that particular case, whilst there was no right of property, it was recognised that ownership interests in fishing and land use were things that ought to be protected as part of this. And again, Australia was required to consider compensation alternative for ensuring the survival of kind of long-term values. So that's kind of fisheries. The other area where kind of property rights have been considered here is marine genetic resources. So in a kind of whistle-stop way, anything which is in national jurisdiction is subject to sovereignty and sovereign rights. It falls on the continental shelf or the EZ, and so the coastal state has exclusive jurisdiction to regulate those as it sees fit. But we haven't really had much kind of jurisprudence or practice on the extraction resources within those kind of regimes at the moment. Where we've seen more of the kind of developments is within areas beyond national jurisdiction with the BBNJ treaty. And again, this is probably more important for me because it's thinking about how these kind of property rights issues kind of operate within a kind of common space or areas of national jurisdiction. Now, interestingly, when you look at the text of the BBNJ agreement, it actually seems to kind of reject the idea of property rights existing. So under Article 11, it states that any kind of claims or activities shall not constitute the basis for claims to any part of the marine environment or its resources. So it suggests that property doesn't exist, but that kind of then flies in pace of them what the other kind of textual provisions of the BBNJ agreement do, which in effect disaggregate property into some and then Articles 14 to 16 treat MGR as kind of property by, for example, requiring benefit sharing and use in a kind of social issue. And I think this is really interesting because this is probably one of the kind of first international instruments where we've seen a rights-based approach here, and it's not explicitly a property rights-based approach. It is one which certainly, for example, recognizes the interests of indigenous people communities, where this kind of distributional kind of discourse coming into play here. And if you look at the kind of wider provisions of the BBNJ agreement, many of its provisions start to talk about the kind of participatory process, the rights of people to be involved in the kind of decisions, and ensuring that the use of these kind of spaces and activities don't infringe their kind of traditional knowledge or positions. So participation is a way of kind of feeding into kind of how property type interests might be protected. And the last point on the kind of BBNJ agreement, which I, again, am excited about here, is that it talks about stewardship in the kind of preamble to the agreements here. So it kind of, I can't remember the phrase, I should know this because I like it so much, but it talks about states as having to act as stewards on behalf of current and future generations here. And for me, this is a kind of very interesting concept here because stewardship is firmly grounded within a kind of property discourse, and it provides lots of opportunities for us to kind of flip and change our thinking away from exclusive benefits of some to the responsibilities of use for other parties. But again, that depends upon us having a kind of clear and well-established sort of framework for thinking about what the benefits are going to be there. As I said, I probably don't have time to go through all of those. I'm approaching 40 minutes. So I'm going to stop very quickly then with some final kind of reflections here. So this is a work in progress, but I think looking in the future, I see this kind of as being a kind of an important space because as human activities intensify at sea, then we're going to have potential conflicts between use. We're going to have more commercialization of activities. And so questions will be asked about how we balance these private interests across and between these types of things. And as we've seen, this kind of growing discourse of human rights jurisprudence, the potential that is going to be part of the framing of it's about this. And particularly when we think about things like subsistence and small-scale fisheries, where there is a really strong agenda from, for example, the FAO to inject a human rights discourse into a kind of resource exploitation activity, I think that potential is much stronger. The second observation, I think, is that at the moment, human rights discourse tends to be regionally grounded. And so we're standing to see a little bit of a bifurcation of kind of values and approaches on a regional basis. And that can be problematic when we think about common spaces, although much will depend upon the jurisprudence, maybe cross-fertilizing forward. The third point here is, and again, going back to my core argument, at the moment, we're seeing a limited space for human rights to kind of defend private interests. But we need to think about how it can inform and shape a debate about the public use and the public beneficiaries of property. And that's where I think a bit of research is needed. And the last point I'll make here is that whilst I've talked about the right to property, what's clear from the jurisprudence is that it doesn't exist in a vacuum. And I think actually it's the kind of cross-fertilization aspects of non-discrimination and Indigenous rights, which maybe provide some of the basis for that kind of public discourse to develop. So I shall finish there, and thank you for your attention, and I look forward to the questions.
Thank you very much.